Welcome. Today we're going to discuss an opinion granted by the Court of Appeals for the Fifth Circuit in Future Proof Brands versus Molson Coors. My name is Scott Slavick. I'm the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I'm happy to help. A recent decision highlighted some of the evidentiary challenges in seeking preliminary injunctions and provided guideposts to overcome those challenges. In Future Proof Brands versus Molson Coors, the Court of Appeals for the Fifth Circuit affirmed the district court's denial of a motion for a preliminary injunction on a trademark infringement claim. Future Proof sued Molson Coors for trademark infringement, seeking to preliminarily enjoin Coors from selling and marketing products confusingly similar to Future Proof's Brizzy trademark. While preliminary injunctions are inherently preliminary, the Fifth Circuit in Future Proof affirmed the district court's insistence on a very high factual burden before the benefit of discovery, particularly when a mark is considered relatively weak. Hard seltzers are packaged alcoholic beverages generally containing carbonated water, alcohol, and in most cases, fruit flavors that have enjoyed skyrocketing popularity in the United States. Beverage manufacturers have rushed to capitalize on that trend. Future Proof and Coors are just two competitors in what is the fastest growing alcoholic drink category in the United States. In 2019 alone, sales in the hard seltzer category in the US hit over $1 billion and are projected to reach $2.5 billion by 2022. Although the market was dominated by smaller upstarts in earlier years, in 2020, several of the biggest beer brands, including Coors, Corona, and Budweiser, have entered the market. Future Proof is a growing beverage company founded in Austin, Texas, which in 2018 secured a $1 million investment from Mark Cuban, while during their participation in CNBC's popular pitch contestant show, Shark Tank. Among their other beverages, Future Proof markets and sells its Brizzy, which it calls a seltzer cocktail. Brizzy comes in several flavors and, like most hard seltzers, boasts a lower calorie count than many traditional cocktails. Coors Hard Seltzer product, launched in conjunction with Coca-Cola, launched in the first quarter of 2020 and is part of Coors' effort to gain in this growing market. Both canned carbonated beverages are named with a variation of the word fizzy and are available in several fruit-centric flavors. As the court noted sarcastically, neither company was the first to have the inspiration to brand a carbonated product with a variant of fizzy. The court's visual comparison of the cans showed several differences, including shape, size, color, and font and formatting of the text. And in its sister circuits, in the Fifth Circuit, a party seeking to obtain a preliminary injunction against alleged trademark infringement must show four elements. 1, a substantial likelihood of success on the merits. 2, a substantial threat of irreparable injury if the injunction were not granted. 3, that their substantial injury outweighed the threatened harm to the party whom they sought to enjoin. And 4, that granting the preliminary injunction would not disturb the public interest. The first factor, likelihood of success on the merits, is the critical factor, and for Future Proof here, the fatal factor. Although different federal circuits have slightly different articulations of the factors used to determine whether a party is likely to succeed on the merits of its trademark infringement claim, overall they are substantively similar. Courts in the Fifth Circuit consider 8 factors. 1, the type of the mark infringed. 2, the similarity between the marks. 3, the similarity of the products. 4, the identity of the retail outlets and purchasers. 5, the identity of the advertising media used. 6, the defendant's intent. 7, evidence of actual confusion. And 8, the degree of care exercised by potential purchasers. In this set of factors, the last 2 are particularly weighty, with the last factor, actual confusion, being the best evidence of a likelihood of confusion. Unfortunately for litigants, courts have wide discretion in applying and weighing these factors, leading to a highly case-specific inquiry which can lead to a lack of predictability and consistency. Underlying any motion for a preliminary injunction is court's general hesitancy to grant such extraordinary relief. Thus, litigants must be well prepared and marshal any and all facts to show as convincingly as possible that without this drastic relief, they will suffer irreparable harm. Appellants challenging the denial of a preliminary injunction face a further uphill battle as the standard of review, abuse of discretion, is highly deferential to the district court. The district court here found that three of the factors, the similarity of the products, the retail outlets and purchasers, and the advertising media used, weighed in favor of enjoining Coors from marketing and distributing Vizzy. However, the other factors, the more critical factors, weighed against enjoining Vizzy. The court held that Coors' mark, Brizzy, was suggestive because consumers must exercise the imagination to connect Brizzy with a carbonated beverage. Further undermining Future Proof's argument is the vast number of third parties aside from Brizzy and Vizzy in the beverage marketplace using the Izzy route, showing the mark is inherently weaker. Future Proof also argued that the lower court was wrong to focus on visual differences in the packaging and overlooking the oral similarities between Brizzy and Vizzy. Neither argument was availing. Regarding packaging, the appellate court noted that determining the similarity of the marks requires an assessment of how a consumer and the reasonable person would perceive the marks as similar enough to have a common origin or association, and thus assessing the visual impact of the marks and products is logical and relevant. Future Proof's argument that oral similarities in this context are particularly important because consumers often purchase alcoholic drinks in verbal request in bars and restaurants was not given much weight because Future Proof provided no evidence that its seltzers sell primarily or at all in bars and restaurants. Of course, a plaintiff is not expected to proffer all of the evidence it would have at the end of discovery, but this is a clear indication to movements that they must present strong evidence that not only was the competitor aware of their mark and product, but intended to adopt or imitate the product or its distribution methods to capitalize on the movement's reputation. Here, this factor seems particularly fact-specific. Is it unreasonable to assume that a large company would be trying to piggyback off the profit of a much smaller regional company, or was the behemoth riding an upstart's wave to greater profits? Finally, turning to the most prominent factor, actual confusion and consumers' degree of care, Future Proof again failed to proffer sufficient evidence to show that consumers, distinguished from wholesalers or retailers, were confused or make snap purchasing decisions. Another warning to litigants, in addition to factual allegations, affidavits from customers can be critical to demonstrating the key factor of actual confusion. This David and Goliath style trademark clash between beverage companies highlights some of the challenges of obtaining preliminary injunctions against competitors who have yet to fully enter the market. One key takeaway here is, despite the urgent nature and emotion for a preliminary injunction, a movement must be prepared with as many facts as possible, supporting each and every factor in the likelihood of success determination. This evidence can include allegations in the complaint, but consumer affidavits can be even more persuasive. Of course, this evidence is difficult to obtain before discovery, and Future Proof did include a creative and robust presentation of secondary evidence, but it was not sufficiently targeted to showing the particular elements of likelihood of success, namely consumer confusion and bad faith. Perhaps, for example, including consumers' social media posts expressing dissatisfaction or confusion, or other evidence of consumer confusion in the alcohol industry more broadly would aid future movements. Finally, in light of the late Justice Ginsburg's ruling in USPTO versus Booking.com, holding that generic .com terms may be recognized if they have acquired secondary meaning to consumers, this case is an example of the distinction between registrability and enforcement standards. While Brizzy is a registered mark, it may still not ultimately be a strong enough mark to warrant broad protection and deference. Here again, we see trademark law struggle to bridge the divide between marketing considerations of picking a brand name which is descriptive, understandable, and memorable, and picking a strong trademark. It remains to be seen whether Future Proof has only lost the battle or the war against alleged infringers. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.